Good afternoon, everyone. I apologize for the delay, but nevertheless, we will start the next session of our conference, Development of the European Patent System. My name is Guntis Ramāns, and I am Director of the Department of Examination of Patents of Latvian Patent Office. And it's my privilege to be the moderator of the first part of this panel. During this panel, we will be informed about the role of European Patent Office in European Patent System. We will be informed also about the situation with unitary patent in Unitary Patent Court. And at the end of session, we will hear opinion of the representative of small and medium-sized enterprise about the patenting strategy. Our first speaker is Doctor-in-Law and Vice President of the European Patent Office, Mr. Alberto Casado Cerviño. He heads the European Patent Office Directorate General Operating Support, which is in charge of delivering support for the patent granting process to internal and external users of European Patent Office services and covers quality management, patent administration, and information management. Alberto Casado Cerviño has extensive experience in intellectual property. He was the Director General of the Spanish Patent and Trademark Office and previously served as Vice President of the Office of Harmonization in the Internal Market. He will speak about the role of European Patent Office in European Patent System. Mr. Casado, the floor is yours.
Thank you. Thank you, Guntis. Thank you very much for your kind presentation. As you mentioned, we are going to talk about the EPO role, the current situation of the EPO. I would like to start saying that I am very happy of being here in Latvia, in Riga, and at this important and inspiring conference organized by the Latvian office in the framework of the Latvian presidency, and to speak to you all on behalf of the President of the European Patent Office. During my talk, I will start with some facts and figures about EPO. In fact, I am going to give you the last figures that we received, the figures, the 2014 figures that have been published a week ago. Also, I will explain also the cooperation with member states, with particular focus on today's host country, Latvia, and I will speak about the quality management at the EPO and about the unitary patent and its latest developments. Let me start by reminding you some important dates in the EPO history. In 1973, the European Patent Convention was signed by 16 countries. 4 years later, in 1977, the EPC entered into force in 7 countries, and the EPO was founded. And in 2013, 2 years ago, 40 years later, the foundation of the European Patent Convention, we celebrated its anniversary with 38 member states. The EPO's mission is to support innovation, competitiveness, and economic growth across Europe. We, at EPO, are convinced that this can be achieved through a commitment to high quality and efficient services. We provide patent protection in up to 40 European countries. It's important to note that the EPO is self-financed with an annual budget of around 2 billion euros. Its staff count around 7,000 employees with more than 30 nationalities. And in terms of procedures, the EPO also acts as a receiving office for international applications and carries out 40% of all international search procedures and 48% of all international preliminary examination. The EPO received last year over 274,000 filings, an increase of about 3%. This is in line with the trend observed over the last 5 years, with annual increases between 2% and 40%. Of course, there are big differences when looking more closely at the geographical origin of those filings. Those from Europe that represent 35% of the total remained stable. The situation with filings from Asia, however, shows significant swings. China up by 18%, representing the 9% of the total. South Korea up by 2%, but filings from Japan down by more than 4%, continuing the trend from the last year. Filings from the US rose by almost 7%, confirming American companies in their ranking as the top filers at the EPO, representing 26% of the total in 2014. The top 5 countries of origin were again the USA, Japan, Germany, China, and South Korea. And if we have a look at the granted patents, we realized that the EPO granted more than 64,000 patents in 2014. Most patents went to US companies, followed by applicants from Germany, Japan, France, and Switzerland. If we analyzed the applications by technical fields, European companies filed the greatest number of applications in 9 of the 10 most active fields. The only exception being computer technology, where Asian and US applicants were dominant. Medical technology was again the field with the highest volume of applications. Biotechnology, electrical machinery, and computer technology grew the fastest, while applications in pharmaceuticals dropped significantly for 2nd year in a row. Looking at the top applicants, Samsung, South Korean company, again headed the list of the largest applicants at the EPO in 2014, followed by Philips with a very important increase, and Siemens. Among the 10 most active filers, 5 companies came from Europe, 3 from Asia, 1 of them from China, and 2 from the USA. The majority of these companies work in the electronics and IT sectors. As a conclusion, having a look at these figures, is that all these figures show that Europe continues playing a key role as a global hub of technology and innovation for a growing number of companies from around the world. We are global players, and we continue being a worldwide player. Cooperation. Cooperation is part of our EPO tradition. You know, the European Patent Convention currently has 38 member states. However, European patent applications and patents can also be extended at the applicant's request to Bosnia-Herzegovina and Montenegro. This is the reason why before I mentioned that we can protect the European patent in up to 40 European countries. Recently, validation agreements have been signed with Tunisia, still to be ratified, and with Morocco, which have been ratified and have entered into force 3 days ago. 2 days ago, the 1st of March of this year. And we are now negotiating agreements with 2 other countries, Moldova and Georgia, and with one international organization, l'Organisation Africaine de la Propriété Industrielle. Talking about cooperation, I would like to underline that member states are our first priority. The EPO sought to put cooperation on a more systematic and efficient footing instead of following a case-by-case approach. Therefore, a strategic document, the Cooperation Roadmap, was adopted in 2011, and under this document, under the roadmap, each national office works with the EPO to develop a bilateral cooperation plan detailing agreed projects. This approach, this bilateral approach, allows us to focus on country-specific needs. In the case of Latvian Patent Office, the EPO and this host office have a constant and strong cooperation tradition. And this cooperation covers mainly training for staff, support for candidates for the European Qualified Examination, IT services, patent information services, and joint events like this high-level conference. I would like to use this opportunity to thank the Latvian office, its team, its director, for the very good cooperation that we are enjoying together. Let me now talk about quality at the EPO. Quality is our strategy. The high quality of the products and services delivered by the EPO is recognized across the patent world. This reputation is confirmed not only by user surveys regularly carried out by the EPO, but also by external user studies. Users rank EPO #1 in quality. The question is, why is that so? And the answer, if you allow me, is very simple. It's because we have a clear and consistent quality policy with clear and continuous improving annual objectives and highly quality staff. This is the human being in our office is our main asset. And as part of this policy, we have recently implemented a new quality management system, some of which core elements are shown in this slide. And we have also achieved the ISO certification 9001 of the patent granting process. That means that all our granting process has been certified last year. This founds an efficient and transparent framework for continuous improvement in quality. Let me now turn to the unitary patent. The European patent with unitary effect will be soon another option for users, besides already existing national patents delivered by the national office like the Latvian one and our classical European patents. A unitary patent will be based on a European patent granted by the EPO under the provisions of the European Patent Convention. The unitary patent will thus not affect the EPO's day-to-day search, examination, and granting work. However, the EPO will take on a number of additional tasks. For example, the EPO will administer the patentee's request for unitary effect. We are now preparing the implementation in cooperation with the Select Committee. Mr. Jérôme Debrulle, the chair of this committee, will inform all of you in detail about the current situation of the committee works. At EPO, the technical preparations for handling of the unitary patent will be ready by the end of this year. You have heard from the Commission representative that we hope that in 2016 the unitary patent will be into force, or will be applied, and that you come, in that case, to enjoy the protection, the additional protection given by this new legal title, and the EPO will be ready at the end of 2015 to fulfill the technical and legal obligations. The unitary patent covers 25 EU member states, and from the 20th of January 2013, the UPP regulations have entered into force, and they will apply from the date of entry into force of the agreement of the Unified Patent Court. You already know that 6 countries have already ratified the agreement on the Unified Patent Court, and we know that some other countries have already indicated their intention to ratify the agreement this year, in 2015. Therefore, the new court is a key element of the new patent system. This unified patent court will have exclusive jurisdiction to deal with infringement and revocation actions concerning both European and unitary patents. There are 2 instances you can see in this slide. The first instance, and the Court of Appeal. And the territorial competence of the Unified Patent Court of first instance is either in the contracting state where the patent infringement has occurred or may occur, or in the contracting state where the defendant has its residence or place of business. The Court of First Instance is split into different bodies. First, for infringement, it will be composed from either local divisions or regional divisions, whereas second, the central division is to deal with revocation actions. Latvia agreed with Sweden, Estonia, and Lithuania to establish a regional division in Stockholm. It was also agreed that hearings of the regional division could take place in other places, like here in Riga, Vilnius, or Tallinn. Madam Susanne Sidborg is going to explain to us in detail how this regional division is going to work. And talking about the central division is divided, as also you can see in the slide, in 3 sections: London, in charge of human necessities and chemistry, Paris, the seat of the presidency, and in charge of textiles, transporting, and physics and electricity, and Munich, in charge of mechanical engineering, lighting, and so on. Thank you. And this slide you can see the location of the main institution, included the other bodies that have been created around the unitary patent, mainly the Mediation Center and the Judicial Training Center. In relation to the Judicial Training Center, also I think this of great interest for all of you to know that last week they have already started working, they have already organized the first training course for European judges. If we talk about the basic principles of the unitary patent, well, here you can see in this slide these basic principles. I think that they don't need too many explanations, but I would like to underline two of these elements. The first one is that the registration of a unitary patent at the EPO will require only one single administrative step. This is very important because that means that will be a very simple and very easy procedure that we are going to apply to, at the request of the applicant, to offer you the new legal title. And secondly, and this is important to underline that, is that the unitary patent is one additional option to protect patents in Europe that can be combined with the classical European patent. Talking about the objectives of the unitary patent, well, you can see that the clear and the most important one are to establish a very attractive, less expensive and less cumbersome system. And this is what we are looking for. We are looking for to offer to all of you, to the industry, a new system that is going to allow you to get protection, unitary protection, in at least 25 European countries, meaning that you are protecting in most of the European territory your innovations. I would like to conclude adding a few words about the EPO Vision and Goals. First, is something that we always underline, is we support innovation across Europe and play a leading role in developing an effective global patent system. Our processes will empower our people to use their knowledge and skills to the full. Our cooperation activities with the Member States are aimed at providing the users of the European patent system with the high-quality services they require. We are strengthening the network with national offices in the Member States by way of the European Patent Network, promoting interoperability. And finally, the EPO does look forward to an enhanced cooperation with Member States with the ratification and the implementation of the unitary patent. Thank you very much.
Thank you very much. Again, that was Alberto Casado Cerviño, Vice President of the European Patent Office. He will explain for us the basics of the European patent system today. But the next two speakers will speak about the unitary patent that will be the future of European Union. The second speaker is Mr. Jérôme Debrulle from Belgium. He is director of the Belgium Intellectual Property Office. He represents Belgium with the Administrative Council of the European Patent Organization. In the second half of 2010, he was, during the Belgian presidency of the European Union, the chairman of the working group patent of the Council when the compromise on the translation arrangements of the unitary patent protection has been negotiated. He has been elected in March 2013 as chairman of the Select Committee of the European Patent Organization, which is the committee that will set the level of the renewal fees for European patent with unitary effect. He will speak about the importance of the unitary patent for Europe and about the implementation process of this patent. The floor is yours.
Thank you very much for this kind presentation. Good afternoon, ladies and gentlemen. The objective of my presentation will be to describe the current situation of implementation of the unitary patent protection within the Select Committee. I will start by recalling some general features of the European patent with unitary effect and also of the legal framework for its implementation. And then I will concentrate my presentation on the current situation of the implementation. Let me start by recalling what is a European patent with unitary effect. As Alberto Casado has said, it is a patent granted by the European Patent Office, and it is an important option to build up the new system on the existing one, on the one granted by the European Patent Office under the rules and procedures laid down by the European Patent Convention, but which benefits from a unitary effect by virtue of an EU regulation in respect of all EU participating member states. It means the 25 EU participating member states in the enhanced cooperation. All EU member states except Spain, Italy, and Croatia. As it has also been said by Alberto, it is a new option for the European patent holder. And this slide, I will briefly comment this slide, represent this new option. You have the 38 EPC contracting states. You can make a distinction among those 38 EPC contracting states. You have a first group of 25 EU member states which participate in the enhanced cooperation. Then you have 3 EU member states which do not participate in the enhanced cooperation, but which could join in the future the enhanced cooperation, namely Italy, Croatia, and Spain. And then you have the 10 EPC contracting states which are not EU member states, but we will see which have an interest in the implementation of the unitary protection in the context of the European Patent Organization. In the current situation, the patent holder may choose to validate its European patent in one, several, or all 38 EPC contracting states. In the future, when the UPP will become operational, there will be one new option, only for the first group of 25 EU participating member states. For this first group of EPC contracting states, the patent holder will have the choice to either validate its European patent is one, several, or all 25 EU participating member states, or, and this is a new option, request the registration of a unitary effect in respect of all those EU participating member states. And this patent will have a unitary effect in respect of all these states. And this is the major achievement of the reform. And I think it's important to underline that the definition of a European patent with unitary effect, in fact, establish a close interaction between two legal frameworks. The European Patent Convention on one hand, which will regulate the filing of a European patent application, the examination procedure, the grant procedure, which is administered by 38 EPC contracting states within the governing bodies of the European Patent Organization, and the administrative tasks are performed by an administrative body, the European Patent Office. And to this European patent, a unitary effect will be attached. And this unitary effect is regulated by another legal framework, the EU regulations 1257 and 1260. They define the condition, the scope, the effect, and the translation arrangement of the unitary effect. And they will be implemented by the 25 EU member states, not by the 38, of course. And you will see that administrative tasks will be performed by the European Patent Office. This is expressly foreseen by the EU Regulation 1257, and here I will quote the provision. It's Article 9.1 of this regulation, which says that the participating member states shall, within the meaning of Article 142 of the EPC, give the EPO administrative task to be carried out in accordance with the internal rules of the EPO. It means that the EU regulation asks the member states to entrust administrative tasks upon the EPO. And those tasks are clearly defined in the EU regulation. It is the administration of the request for the registration of the unitary effect. It is the administration of the compensation scheme for the reimbursement of translations cost under certain circumstances. It is the publication of the translation of European patent specification during a transitional period of time. It is the administration of the register for unitary patent protection, and it is the collection and administration of renewal fees. As you see, those administrative tasks are clearly enumerated in the EU regulation. Second aspect is that the EU regulation foresees the setting up of a select committee within the framework of the European Patent Organization. It is foreseen in Article 9.2 of the EU regulation. The composition of the select committee is the following. The members of the select committee are the representative of the 25 EU participating member states. There is also the president of the EPO, which represents the office within the select committee, and who may submit proposal to the select committee. The European Commission is also represented within the select committee as an observer de jure. The European Commission has a specific role to play within the select committee, and I will come back to it. And then there are 11 EPC contracting states which are not participating in the enhanced cooperation. And they have, of course, an interest in the decision that the Select Committee will take because they will be attend to the impact of the decision on the budget of the whole European Patent Organization. Then you have two NGOs representing the users of the European patent system, namely Business Europe and EPI, and you also have two more institutional observers, the Board of Auditors of the European Patent Organization and the representative of the staff of the EPO. Now, what are the voting rules within the Select Committee? I mentioned this even if, until now, almost all decisions have been taken by consensus. But we will now have to take the more difficult decisions. So I think it's maybe important to recall what will be the rules in order to take the decision. The right to vote is, of course, restricted to the EU participating member states. Each EU participating member state has one vote. Before any voting, the representative of the European Commission shall be in a position to give its opinion on a proposal submitted to a vote. And in principle, decisions are taken by a simple majority of votes. I say in principle, because there are a lot of derogation, and a qualified majority of 3/4 of votes is required for the main decision. The rules relating to the unitary patent protection, the rules relating to the fees, any other decision or rule having a budgetary or financial nature, it's a broad category of decision or rules, and of course the rules of procedure of the Select Committee itself. Now, what are the main tasks of the Select Committee? There are in fact 3 tasks, and they are foreseen in the EU regulation. The first one is to ensure the supervision and governance on the activities of EPO related to the task that will be entrusted upon the EPO. So the Select Committee will have the responsibility to control the way the EPO will carry out the task that will be entrusted upon the EPO. Second important task is to set the level of the renewal fees in accordance with Article 12 of the EU regulation. And last task is to set what we call the distribution key. It means a distribution key of the share of renewal fees that will be distributed among the EU participating member states. And now I will comment those three tasks by saying you what is the current situation within the Select Committee regarding each of these tasks, because for each of these tasks corresponds one main decision. First main decision is the adoption of the rules relating to the unitary patent protection. And we can define those rules as the rules which will regulate the administrative procedure that the EPO will manage in order to carry out the task that will be entrusted upon the EPO by the EU participating member states. And the committee has approved during its meeting in December of last year those rules, and you can find the consolidated version of those rules on the website of the EPO. On the next slide, you will see the general structure of the rules, and I will not enter into too much detail concerning those rules, but I would like to underline, to emphasize some of them, which are, I think, of interest for you. The first is in part 1. You will see that part 1 of the rules relates to the institutional provision, and in chapter 1, you have a provision which foresee that the EPO shall be bound by the decision of the Unified Patent Court under Article 32, paragraph 1, little I of the UPC agreement. And this article refers to the decision of the UPC on appeal against the decision of the EPO for the administration of the unitary patent protection. So it means that there is a judicial appeal against the decision of the EPO before the UPC when the EPO will administrate the unitary patent protection. Another important provision is in Chapter 3 of Part 2. Part 2 concerns the procedure to be carried out by the European Patent Office. In Chapter 2 of this Part 2, it concerns the compensation scheme. And this is a scheme for the reimbursement of the translations cost when patent applications are filed in an EU official language other than an EPO language. And this is one of the aspects of the translation arrangement. And this scheme is only available for some categories of beneficiaries like SMEs, natural persons, which have their residence or principal place of business within the European Union. Maybe a last provision in Part 3 relating to the information to the public. Chapter 1, this chapter defines the entries in the register for the unitary patent protection. It means that it defines the information relating to the unitary patent protection that will be available through the register. Now, the second main decision, of course, relates to the renewal fees. And before describing the current situation, I would like to recall what are the main provisions contained in the EU Regulation 1257. Firstly, for each annuity, a unique renewal fee will have to be paid to the European Patent Office. It means that the collection of the renewal fees will be centralized at the EPO. And this is a major administrative simplification in comparison with the current situation where renewal fees have to be paid in each EPC contracting states where the European patent has been validated. Secondly, the level of the fees will be progressive throughout the term of protection of the unitary patent. And this is an important feature of the structure of the renewal fees because you can have different types of curve of progression. Then the EU regulation foresees no less than 9 parameters in order to define the level of the renewal fees, and I will only mention some of them. The first one is that the level of the renewal fee shall have to facilitate innovation in Europe and foster the competitiveness of European business. And this is, of course, the main political objective of the whole reform of the European patent system. The second parameter is that the level shall have to take into account the situation of specific entities like SMEs. And these parameters has been introduced in the EU regulation on the request of the European Parliament. But the EU regulation does not define the way to take into account the situation of those specific entities. It can be done through fee reduction, specific fee reduction for SME, but it can also be done by the general amount of the renewal fees, or by the curve of progression of the renewal fees. But at the end, the level of the renewal fee, the structure of the renewal fee will have to take into account the situation of those entities. Third parameter, the level of the renewal fee shall have to reflect the size of the markets covered by the unitary patent protection. And the 25 EU participating member states represent a market of almost 400 million inhabitants and a GDP of 10.44 trillion euro. And we have to make comparison also with other markets with this size and to see what are the price of the patenting of innovation. Next parameter is that the level of the renewal fee must be equivalent to the level of the renewal fees to be paid for the average geographical coverage of current European patents. And this is an important parameter. On the basis of the statistical information provided by the EPO, it appears that this average geographical coverage of current European patent is, in fact, the territory of the 4 EU member states where European patents are the most validated, namely Germany, France, UK, and the Netherlands. And last but not least, the level of the renewal fee must be sufficient with the pre-grant fees in order to guarantee a balanced budget for the European Patent Organization and to cover all the cost of the EPO for the administration of the unitary patent protection. So you see that it will not be an easy task for the Select Committee to set the right level of the renewal fees. It means a level which will take into account all those parameters. The level will have to be low enough in order for the UPP to be attractive to the users and high enough in order to guarantee the financial sustainability of the European Patent Organization and the national offices. Now, what is the current situation? In fact, the Select Committee is now in a position to take soon a decision on the level of the renewal fees, because he has at his disposal all the necessary information to take a decision. Firstly, he has a methodology to simulate different fee level scenarios and their impact on the EPO income. He has also simulation of fee reduction for SME. He has also estimation of the cost for the administration of the UPP by the European Patent Office. And he has draft budgetary rules and draft accounting rules for the revenues and costs relating to the unitary patent protection. In fact, in the course of this week, a proposal of level of fees will be submitted to the Select Committee. And in principle, the Select Committee should take a decision on the level of the fees by the end of June 2015. Now, the last decision to be taken by the Select Committee relates to the distribution of the renewal fees. The EPO will collect the renewal fees, and 50% of the renewal fees will be retained by the European Patent Office in order to guarantee a balanced budget for the European Patent Organization. The remaining amount shall be distributed among the EU participating member states and should be used for patent-related purposes. And the distribution among the EU participating member states should be based on fair, equitable, and relevant criteria, which are foreseen in the EU regulation. And those criteria are the following. The first one is the number of patent applications. And we are discussing about what it means. Does it mean European patent application, national patent application, first filings? The second criteria relates to the size of the market, while ensuring that a minimum amount of money shall be distributed to each participating member states. And the third criteria is a compensation factor for EU participating member states which have an official language other than one of the official languages of the EPO, or which have a disproportionate low level of patenting activity, or which have acquired membership to the European Patent Organization relatively recently. Concerning the distribution key, the Select Committee has initiated the discussion in December 2014, and 2 weeks ago, a workshop has been dedicated to this question, and the main objective of this workshop is to analyze a possible methodology to simulate different distribution key, and also to see what are the most relevant data in order to quantify the criteria and what should be the weighting of the different criteria. So this is the situation of the activities of the Select Committee. In conclusion, what I can say is that since the creation of the Select Committee in March 2013, a lot of work has been done in order to implement the unitary patent protection. The legal implementation is almost completed by the adoption of the rules relating to the unitary patent protection. Concerning the financial implementation, the level of the fees and the distribution key, we can say that the Select Committee is in a position to take soon a decision on regarding the level of the fees, but much work needs to be done concerning the distribution key. Thank you for your attention.
Thank you very much, Jérôme Debrulle, Chairman of the Select Committee of the European Patent Organization and Director of the Belgian Patent Office. The next speaker is Mrs. Susanna Åsa-Swiberg, Director General of the Swedish Patent and Registration Office. Mrs. Susanna was appointed as Director General at the Swedish Patent and Registration Office in 2008 by Swedish government. Prior to this, she had held various globally leading positions in private sector in the field of intellectual property for large international companies such as Electrolux and AstraZeneca. She is Master of Science in Civil Engineering from Royal Institute of Technology, and she is qualified European Patent Attorney. She is member of the board of the Royal Institute of Technology and Swedish Defence Material Administration. She will inform us about the other side of unitary patent, that is about the Unitary Patent Court and its regional offices. The floor is yours, please.
Thank you very much, and also thank you very much for asking me to speak at this very interesting conference here in the beautiful Riga. And by the way, the weather is a lot better than it was this morning. Today, we have been informed about many different aspects of IP, and I know there will be even more tomorrow. So we are concentrating on patents and the development of the patent system in Europe. I have been asked to give you an update on what is ongoing in relation to the Unitary Patent Court, or the UPC, as we sometimes name it. And especially to dwell a bit on what is happening here in the Nordic-Baltic region in that respect. Well, Mr. Casado has already told you all about what is happening with the European Court and how it has been built up, but I thought it could be quite good to just give some very general information. I won't repeat all of it, but the important thing here is that the member states, those member states that will be members or have said that they are interested in ratifying or joining the European Patent Court system, can choose to have either a national division of the Court of First Instance, or to be members of a regional court or a regional division. And this is what I will concentrate on. But I just want to give you a bit of an update on what's ongoing on the more general, or the sort of the Court of the First Instance, and on the general level. On the central level, there are 5 work streams that are being worked on within the preparatory committee. The preparatory committee is the select committee of the European Patent Court system, one could say. But it is a separate committee, and the members of the committee are the member states, those that are interested in joining and ratifying the European Court system. And as I said, there are 5 work streams here. There is one which relates to the legal framework of the unitary patent court system. There is one about the facilities. Of course, if the court is going to have 3 different seats, you will have 3 seats in the court of first instance on the central level or a general, and then you will have the appeals court that will be based in Luxembourg. And the facilities, to find facilities for these 4 parts of the court is work that is ongoing. And as we have heard, one will be in Paris, there will be one in Munich, and there will be one in London for the court of first instance. There are, of course, financial aspects of the court system as well, and that is also being dealt with by the preparatory committee. Human resources and the training of judges is, of course, a very important part of it. After all, there won't be a court unless you have very qualified judges. And as we heard, the first training course was organized just a couple of weeks ago in Hungary. And then we have, of course, the IT framework. IT is extremely important. And as the court will be spread out on the first instance in 3 different places, and the appeals court will be based in Luxembourg, you will have to have an IT system which is up and running by the day when this is being implemented. So the IT is a framework that is of utmost importance for the future work of the court. So it's a lot of work being done within that area as well. In relation to the ratification process, well, that's a process that's ongoing as well. And we have heard this morning by several speakers already that there are 6 countries that have ratified so far, and that there are others that will come. And we hope that there will be 13 by the time that all the framework and everything that needs to be in place, when that is ready, that we also have 13 countries that have decided to ratify the system so that it can enter into force. And as we have heard, we hope that it will enter into force during 2016. Some think it will be in the beginning of 2016, and some will say we're probably more to the last part of 2016. We will see what happens here. But at least there's very many people that are involved, and many people are working on this to try to get it up and running by the day or the year that has been set for this. Talking now about the possibility for member states to choose to have either a national division or be members of a regional division. Well, it has been said, yes, that why not create a regional division in the Nordic-Baltic area. So once the implementation work started, these sort of initial discussions started with the countries in the Nordic-Baltic region that are members of the EU, which means Denmark, Estonia, Finland, Latvia, Lithuania, and Sweden. And it seemed like a very good idea, considering both the size of our region and also the fact that we share history together. We've done quite a lot of things together, even if we have been separated throughout the years as well. And by the way, we don't understand each other's languages. So everything started with initial discussions in February 2013. The basic starting points then was that it should be all Nordic-Baltic EU member states. We should have only one language, English only, for the reasons I just said. We have different languages. We don't understand each other, except when we speak English. So, and we thought that was, a very good idea. And the main seat of the division, there should be one main seat of the division, but with a flexible organization that would allow for proceedings to be held also in other locations. And at that time, we started to talk about 3 different possible locations for the seat of the division. There were 3 different proposals. Sweden proposed Stockholm. Denmark proposed Malmö, which is city in the southern part of Sweden. So, and Finland proposed Helsinki. So, and of course, we know that from the history that there is always discussions about the seat. That happened also in other places, as we know. So what happened with this? Well, already in December 2013, Finland decided that they didn't want to be part of this. The reason they gave was that the Finnish users were strongly against the flexible organization, and they were also strongly against the language regime with English only. They wanted to have Finnish as well, which of course other countries might not have been that happy with. So the discussions went on, but in February 2014, Denmark decided to leave the discussions as well. They wanted to create a national division in the same way as Finland had decided earlier. The reasons the Danish gave was that it was considered in Denmark to be important to have proceedings in Denmark, in Danish, and with at least one Danish judge, which would not necessarily be the case as the discussions had been so far. So, what was left? Well, Sweden and the Baltic states decided to continue, although it's only 4. Now we started with 6, and now we are only 4. So in March 2014, a regional agreement concerning the Nordic-Baltic regional division of the Unitary Patent Court was signed by Estonia, Latvia, Lithuania, and Sweden. And this regional agreement includes that the countries of the agreement will request the Unitary Patent Court to set up a Nordic-Baltic regional division in the first instance of the court, and the seat should be in Stockholm. The agreement will enter into force when 2 of the states of the agreement, and Sweden has to be one of them as the seat will be in Stockholm, have approved the agreement and ratified the UPC. And the UPC must have entered into force, of course. So where are we now? Well, the setup first. It should be a flexible organization to allow for proceedings to be held in other locations than the seat of the division. The language of the proceedings should be English, according to Article 49.2 of the UPC, with interpretation to and from the national languages, if requested. The division will handle cases under the unitary patent protection and the present European patents. And Sweden has agreed to provide facilities, the administrative support, etc., that are required for the division to be fully operable on the date of entering into force of the UPC. And where are we today? Well, the Swedish Parliament approved the Unitary Patent Court in May 2014, and we ratified it. So we are one of the 6 countries that has ratified it. And in the same time, the regional agreement was approved. So now we're waiting for the others to join us. We know that Lithuania is likely to ratify in November. I hope that will continue, because that means that there will be 2 of us, which is the necessary to actually have a court once everything enters into force. Estonia had general elections last weekend, so 1st of March, okay. So which means that, as everybody knows, when you have general elections, everything is put on hold until the new government is up and running, and it takes normally 6 months or something like that. We have the experience in Sweden. And Latvia is awaiting the finalization of the financial framework, which we have just heard about. So, of course, we are very positive, and we are looking forward to have our neighbors here to join us as soon as possible. of course. And yes, Denmark and Finland could join the regional collaboration at any time should they decide to change their mind. So who knows? We will start with 2, we hope to be 4, and we might be 6 in the future. Who knows? And then, by the way, Norway and Iceland are not part of the EU, so. So where are we on the process of implementation? Well, the work to create the main seat of the court and the Swedish activities under the regional court is ongoing. And there will be a Swedish-Baltic working level meeting later this year, or later this spring actually, to discuss the setting up of the division in more detail. And that's about it. We will see what happens. We're looking forward to it, and we are, of course, as I said, very much looking forward to have our neighbors to join us here so that we can have a regional court in the Nordic-Baltic area. Thank you very much.
Thank you very much. Again, that was Ms. Susan Sivborg, Director General of the Swedish Patent Office. Now we heard 3 presentations, and now we know about the patent environment in Europe today and in near future. But now we will turn to the next speaker, which is Jānis Ošlējs. He is a chairman of the board of the limited liability company Primex. Mr. Ošlējs is the founder of the Primex Group, which is one of the leading companies in construction of industrial concrete floor in Europe. He successfully launched new innovative concrete product, Prima Composite, that is patented worldwide. It won World of Concrete Innovation Award, Las Vegas, United States in 2012 and 2013. Chicago Innovation Award in 2013, and the Best Product of the Year Award in Belarus in 2013 and 2014. Ošlējs also created international partnership devoted to research and development in the sphere of composite concrete. He will share his experience about the patenting strategy and practical problems. The floor is yours.
Thank you very much for the kind introduction. It was very interesting to hear the previous speakers speaking more from the patent office's point of view, and certainly I must give the due to the previous speakers. I'm certainly not a patent attorney. I'm an entrepreneur, so this is more a look from the other side. And how does it look from the trenches of a person trying to patent something? In the beginning, I'll tell real short about what is our product, so you would understand the context of my speech, and then I'll share some of my experiences I've had when I tried to when I successfully patented the product. So what we are doing is we've created a better concrete, a concrete that is stronger than a normal concrete, doesn't crack, far less resilient, far tougher, far stronger, far higher tensile strength than normally you would have with a concrete. And then because the quality is higher, you can build lots of different things. We are kind of specialized in heavy loaded industrial floors, also floors for all kinds of DIY stores. All IKEA stores in Sweden, for instance, lately are done only with this system, but many other systems worldwide. Not only floors, nowadays it's used also in foundations and many other things, concrete. Important is that it's an ecological product. Concrete overall is a huge polluter worldwide. To get concrete, you need to bake limestone. Limestone baking is a very CO2 intensive process. So to get a ton of cement, you need to burn a ton of CO2. you need to burn so much gas that a ton of CO2 is produced. So concrete is responsible for like 6% of global CO2 production, and we can cut the concrete consumption by half, so we can save potentially lots of CO2 emissions. Our concrete flooring systems and other systems are now quite well used worldwide. I think we are #1 system in Scandinavia, but also very strong in both Western, Eastern Europe, Middle East, quite strong starting now in the United States, especially Midwest, and also in India, but in South Africa. So we hope, of course, to expand these geographies, and also we have patented the system more or less worldwide. So basically what we wanted to create a kind of a moat with the patenting, and that was one of the reasons why we started. We listened to Warren Buffett that says that we need to have a moat. In the beginning, of course, we were users of the company. At the beginning of the company, we were more users of intellectual property. So we looked around, we read patents actually of other people, and we tried to figure what's been done. Basically, the technology was built on an expired patent from 1980s. That was how we initially started, and we actually found that even expired patents are not implemented everywhere. So we found, for instance, a niche to bring an expired Belgian patent to Sweden, where it was unknown, and we were quite successful with that. And our moat was more like production system, the tool, machinery, methods. So that was how we went about it. But of course, with time, we discovered more and more issues with the existing system that we kind of took and used, and we started to think about, what can we do? How can we actually make it better? Because it had issues, it had difficulties, and yeah. So we discovered after quite big R&D process involving lots of universities, both from here, from Latvia, but also from Scandinavian countries. We established Prime Composite. We filed a Latvian patent, and so our strategy was to file an easy patent in the beginning. So Latvian patent is easy, and so we filed it, so we would have a priority. And then we followed that by World Intellectual Patent Organization application, which was also successful. And then we went, after that, we decided to go kind of sequentially for the other patents, like in Europe, United States, China, and so. And the strategy was kind of nice in the sense that it works out. We seem to be getting patents everywhere because we have this priority and we have the WIPO, and then we go for the others. So there's a kind of a successful trail. But of course, one of the issues, and we'll touch it later, is time. I mean, we are really dragged out in time following this strategy. Would I use it once more? Not so sure, I think, because simply like these sequential steps are way too long for reality. I mean, we still don't have patents granted in all jurisdictions, and that's like since 2008, so it's like, it's ridiculous. So the length of the patenting process is something that frustrates me. And I mean, I understand that there's a kind of expedited way how to do it. I mean, we chose kind of a normal way due to, lack of experience and stuff, but good in a way because we had time to accumulate cash and more knowledge to go through these patenting stages, but bad as, there's still uncertainty if we will receive patents everywhere. And so still we have a few places where the patents are not granted, but like fully. And so, like I said, it's really, I think it's unacceptable. It's really wrong. Was it anyway right to patent? I mean, we also could have not patented it, but we would have kind of kept it black box. The issue was we decided to license our technology to others. So once you license, you have to you have to discover what it is inside, and then of course, well, you have to disclose, and then it's better to patent, certainly. You can't keep back box, essentially. The whole patenting process for us has involved the formulation of the patent, and the big question was initially that we posed ourselves: shall we hire a patent attorney company that would formulate the patent for us, or shall we do it ourselves? Here in Latvia, there's a quite famous professor in construction field and holder of lots of patents, Professor Lapsa, and he once said that it's best to create your own children by yourself. And I should agree, and what he meant is that, of course, it's best that you write your own patent. And I think that is kind of right. Our experience kind of going through the patent writing process is that the patent agency takes years to understand fully what you are doing. No, not years, but certainly time. And it's far better to write yourself and use kind of the patent experts as experts, kind of to bounce off as a sounding board, to bounce off your ideas. But you should have to write it. And definitely for Latvian audience, I should recommend Professor Lapsa as a really great explainer how to write a patent in an easy way. And I wish we used him earlier, kind of for explanation. But then, of course, for a patent writing and application, we use different company. We use Fortuna's company, actually. Of course, patent is not only patent. Patent is also a product is not only to be protected by a patent. So we are doing multifaceted approach for our IP protection. So we use trademark know-how, branding, sales channels. We license the technology worldwide, and that has been actually successful for us. We've had no IP breaches until now using that technology, but also I think because we have kind of this patent as a basis. We supervise licensees using a kind of a computerized system, computerized supervision system. And so you can say that our patent is about concrete, but is it really, and like how big part of this concrete actually is software is also a really good question that I would like to ask, and I'd touch on it towards the end of this speech. But again, you know, especially nowadays, and especially because so many things are computer controlled in the world, I'm really not happy that in Europe there's difficulties applying for software patents. I think it's wrong. And I think that it would be helpful if kind of European patent law would be more liberal in this sense. Certainly, licensing meant also we need to go for trademark registration, which is certainly something that we did. And we filed the patents globally. What are our learnings from this? The speaker from European Patent Office said about European Patent Office that it's very high quality. I should agree, actually. So we've been interacting now with several patent offices worldwide, and we've been interacting with experts and coming their opinions back on our patent. Not everywhere it went smooth. Sometimes, you know, they raised objections. And I should say that the European Patent Office, in our experience, was really good. We've had far more difficulties in our particular case, like with United States, where we think that a particular specialist should could be of a higher learning. I don't know how to put it. So we're disappointed. of qualification. How can I put it? So and it takes time as well. So that is not okay. Of course, we live in now very globalized world. So of course, I am really happy about all kinds of more unified patents, because a small, very local patent from a small European country doesn't make any sense anymore with the world like where we are. So I'm very happy about all regional initiatives, very happy about the European Patent Initiative. I think it's very good. Definitely happy about the kind of more courts initiatives unifying and regionalizing the issue. I think it's totally right and very, very correct. Hope that one day we'll end up with more like a worldwide patent, but that day may not arrive in our lifetime, but hopefully it will one day. I also wish that in quite many cases where we had patents had more time to kind of understand our product, because typically what happened was that we submit and then there's like years and nobody touches, and then somebody kind of starts to look at it, at the patent. And I wish that patent experts had more time to understand the product, so and kind of do it faster. So to me, what's frustrating with the patenting process is that, I mean, we are paying some fee to the patenting organization, but that fee essentially is small compared to the overall kind of cost that I'm having as an entrepreneur filing a patent, what with all the experts and adjustments and everything. So I really wouldn't mind to kind of pay more, but have somebody that looks more qualified faster and deeper at it. So I think that patent offices should raise the charge, actually, in my opinion, just to be faster, because this backlog and this kind of time spread out doesn't make too much sense to me. Yeah, shorter patenting times. I mean, yeah, I'm coming on the third time on it because it really hurts. So we are guilty, of course, ourselves. I mean, we understand right now that we should have chosen kind of the expedited patenting process and stuff, but I'm sure there are many other gentlemen like us going like the normal way, and it's so slow. So I think it's not okay. Again, you know, perhaps patenting offices should consider raising the fees so you can kind of reduce the backlog, hire more experts, go faster somehow. I don't know. And software patenting is another thing. So I'm not happy that in Europe the software patenting is not allowed. I think that especially nowadays most things are software or software related. I think it's wrong. I think Europe is really falling behind and should do something about it, in my opinion. So conclusions, patenting and patenting process has been essential for us, far more difficult and time consuming than I thought, far more expensive as well, by the way, than I thought, but it's been good fun. I found it very interesting, respectfully traversing experts' opinions, and it was really nice. Yeah, so it was great experience. And thanks everybody for listening. Thank you.
Thank you very much. Mr. Debrulle is the chairman of the board of the limited liability company Primex. Now that is the end of the first part of this panel, and you will be able to ask questions at the end of the second part of this panel. But now I would like to thank all speakers once more and give some presents. Thank you very much. Then that is the end of the first part of this panel, and you will find outside the coffee and something other too.